can you please look up this site?
See if we can figure out something.
All right, ma'am, so I know you can hear me, but we're not able to hear you while you have yourself muted. So you have to unmute yourself. The little red microphone with the slash through it, you need to tap that so that you're unmuted so we'd be able to hear you.
There we go.
There you go. All right, what's your name, ma'am?
My name is Kate Grindstaff.
Okay. So this is a small claims case 2401353 SC. Plaintiff here, KJK Real Estate. Mr. Cameron, can you tell us what you do for KJK Real Estate so I can make sure you can answer for them?
Yep, I'm one of the property managers for them, and I'm assisting with small claims cases.
All right. And then Ms. Grindstaff, we're here for small claims, which means you're asking for this to be resolved here in front of me, as opposed to asking for this to be resolved in front of a jury trial. We're also trying to have this done without any attorneys, small claims specifically without attorneys. So if both parties are ready and able to proceed today here in front of me without attorneys or without a jury trial, then the first thing I'm going to do is swear everybody in who might testify. Go ahead and raise your right hands. You swear or affirm that any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes.
I do.
All right. So it's my understanding this is about mostly about a landlord-tenant situation that occurred some years ago. And ma'am, you do not still live there, correct?
Correct.
All right. And when did you leave?
In 2018.
All right. And that's what I have. My question is for Ross. Ross, I see a landlord-tenant judgment in this case. I did not see a landlord-tenant judgment in the other case. Did you have one in that case as well?
I don't have those documents in front of me. Maybe Connie can help.
Okay, that's neither here nor there. But this is the way it works is when you're still living there, if there's an issue with unpaid rent or eviction, something of that nature, then essentially what happens is you go to landlord-tenant, all right? Now, after the tenancy is over, then if there's still money to be resolved, you could make a small claims case. The problem here in this case is I'm looking at a landlord-tenant judgment for possession that was entered back in May of 2018. Right?
Correct. Yep.
Okay. So essentially what that means is after that date, this is that is the plaintiff asking for right to recover possession of the property. So you wouldn't really be able to sue for any monies owed after that point unless they stayed there and didn't leave.
I believe we'd still be able to go after a money judgment if that's money owed. Is that incorrect?
Well, here's the thing. I understand your logic. You're saying, hey, we had a 3-year lease and they only stayed this much of the lease. And then, so really we have a contract that they owe us every month until the end of that lease. And you're calling that future rent. But once you go evict them and ask the court to give you possession back, that breaks the lease.
Okay, there's a clause in the lease that says that they have a continuing liability for the rent, whether they pay it on time and are a good tenant or whether they don't pay it on time and are a bad tenant and we need to recover possession of that. So it was still her home and Mark's home sitting on our lot for a duration after they moved out for the continuing of that lease. So that's why I'm arguing that I think we're not able to do anything, whether we've got possession and they're no longer there. It's still their home sitting on our lot.
Except that I never received a title for the trailer, so I couldn't remove the trailer. I never took possession of it and we left it with you. So there was no money exchanged of me selling it back to you.
Yeah, but no, here's the problem. You have a court order that says as of May of 2018, whatever's sitting there at lot 53, you have you have the right over that property to rent it out to the next person, right? You have a duty to mitigate that.
Correct. We have the right to the land. It's still her home sitting on our lot. We didn't have a right to her home. This is a lot lease. So we have the right to recover possession of the land, but the home is still sitting on our lot.
Okay, but you're telling me, so they continuously lived there through 2018 through 2019 till the end of this lease?
No, they did not live there.
Well, you can't evict them and then also charge them rent. You can do one or the other.
Okay. Our lease that she agreed to, it says something differently, but
Well, I understand that, but once you go to court and ask for the court to intervene and give you the right to repossess it for a money judgment, that breaks the contract. That's a superseding act that comes into the middle of that lease and says you no longer have the right to just keep living there and pay the lot rent every month, because the lot owner has come to court and said, we want possession of lot 53 back. And it was granted to you by the court.
okay. Well, I'm willing to concede that maybe future rent beyond 90 days may not be recoverable. But I know that 90 days, we don't have the right to go into that home. That's what every court process server has told us when upon eviction. If the tenant owns the home, we may not touch any of the tenant's belongings. We may not go into the home. We've secured it so that they may not live there anymore, but it is not our possession at that point.
Okay, but here's the problem. A landlord-tenant contract is, I pay you money every month and then I have a right to live there. Are you telling me when you say secure the trailer, meaning you lock them out?
Correct.
Then they don't owe you rent. Why would
No,
they pay you rent for a trailer that you put a lock on that they can't go and live in?
Because it's still their home on our lot. I think you mean that the lot lease, what they're saying when they sign the lot lease is that we are agreeing to put their home on our lot for the duration of that lot lease and continuing if they choose so. So
What
whether
I'm
they're
telling
living
you
there, whether they
is
are
if a
living there or not
landlord
is,
puts a lock on a dwelling so that the tenant can't get in there anymore, then you can't also collect rent.
even though their home is sitting on our lot for 90 days after the eviction.
Okay, I guess I'm confused. What is it you put a lock on so that they can't get into anymore?
It's the home.
Then they don't owe you rent anymore because they can't use it as a home anymore, right?
Well, that's still their home, whether they can live in there or not, based on their poor behavior of not paying rent. It is still their home for 90 days at least after
Well, you
the
can
eviction.
say that all you want, but you essentially seized the home, right? They can't get into it and live there.
They may
So
still,
that is a break in the understanding of the landlord-tenant contract. They can't sleep there at night. They don't owe you rent anymore. You chose to put a lock on it. You could have charged them rent for every day they stayed there and didn't leave after you have possession, but you can't put a lock on it so that they can't even get in there and then also continue to expect rent, even if it's in the lease. The lease is broken once you ask the court to intercede and give you possession. And then you still would have right to collect rent if they're still there. But if you then put a lock on it so that they can't even go there, then you can't keep expecting rent.
okay.
And I see some other things here, but let's go through the list because future rent was the big one. But that would be the same with, lawn maintenance. You're essentially saying you're evicting them. They wouldn't need to pay for anything after that date in 2018. That would be the same with utilities. So it seems to me everything you're asking for in this is post-possession judgment.
Correct. Some of it is post-possession judgment. Sorry for the phone call. It is different than what I've heard from other courts regarding post date. I mean, it is still her home, and I'm not sure that I'm conveying this correctly or it's being
I agree, unless you lock her out of it.
No,
That's the
it's
problem.
still her home. I mean, she could still get into it if she gave us a call. The law is that she has the right to her possessions in the home for 90 days afterwards. So if she were to give us a call, we can go take the lock off. She can recover her possessions. We're just doing that to ensure that no one's living in the home because we have recovered possession.
Okay, but you just said it. You're ensuring no one lives in the home. So if no one lives in the home by your actions, then no one would owe you rent.
It's a lot lease. So we are agreeing that the home may live there. We're not even saying that she is approved to live there by signing the lot lease. We're agreeing that her home may live there. So maybe I'm just not gonna, maybe it's like talking to a brick wall because we just disagree on that, but that's how I understand it.
Okay. But that's the difference between when you go into landlord tenant and you ask for possession. You're actually saying, we're throwing out the lease. We're going to disregard whatever the lease says. This is ours now.
Okay, and that's, again, I agree to disagree on that, but you're the judge, so I will go with what you
All
said.
right. So essentially, it feels then that the judge, this would be dismissal without prejudice. And that's kind of why I was asking you about your other matter. I know that that's neither here nor there. There was no service on it, but I didn't see a landlord tenant judgment in that one. And so if that's true, you may have a whole different ball game. Because in other words, if you didn't go into landlord tenant case and you just had like a 3-year lease that says, hey, every month that you're potentially living there, you owe us money till the end of this lease, you can in fact recover that.
Okay.
But this one's different because the court ruling in landlord tenant superseded, and dismantled your contract between landlord and tenant. All right.
Okay.
So essentially, Ms. Grindstaff, I'm assuming you really have nothing to add here, because essentially what I'm doing is explaining that I don't think this small claim suit there would be any damages awarded. I would send copies of that to the parties. Both parties have a right to appeal that decision and say, we don't agree with what just happened there. You must do that within 7 days of today's date. That window of opportunity closes to continue this further to appeal it in front of the district court judges, and you must actually come in and sign that order in person, all right? It's not just an oral request, it's a piece of paper, but Mr. Comrade, I understand I want to make sure you understand you have the right to do that, and then therefore it would go in front of the district court judges and you essentially start fresh. So if anybody gets notice of that happening, you would be expected to also show up in the follow-up hearing. But with that, I can go ahead and release parties for today. I think we're all set.
Thank you, Judge.
Rainy days don't seem so wet. Stormy nights don't stay.